In this recent opinion, and this involves Bank of America, we're going to see what the judge thinks about an argument that showing a charge-off status because it affects the credit score in the algorithms is inaccurate or misleading. So let's take a look, see what we have here. So the defendant, Bank of America, wants to dismiss the plaintiff's lawsuit where the plaintiff said, hey, you willfully or negligently violated the Fair Credit Reporting Act. Now, this is kind of a technical thing. It has to do with a 12B6 motion, which is under the Federal Rules of Civil Procedure. That's a motion to dismiss. And there's also what's called a judgment on the pleadings. And the court says, well, it's basically the same thing, so I'm not going to worry about the difference. All right, so the plaintiff had sued, let's back this up so we can see, had sued Equifax, Discover, Capital One, Barclays, and Bank of America. Basically, resolved it with these three companies, and then Discover wanted it to go to arbitration. All right, so now we have one last claim against the defendant. And the plaintiff says the defendant, Bank of America, inaccurately reports his credit card account as charged off after it was paid off. And it failed to do a reasonable investigation after Equifax notified Bank of America that the plaintiff disputed. So just a reminder, and if you've been watching our videos, you know this is something we talk about virtually every case decision. To get liability under the Fair Credit Reporting Act against a data furnisher like Bank of America, they provide or furnish information to the credit bureaus, we have to notify the credit bureaus, Equifax, Experian, TransUnion, etc. And then they notify, for example, Bank of America. Now Bank of America has an obligation that if they do a lousy investigation, we can sue them on. All right, so we're going to skip kind of this part. We covered that in other videos. So here we go. The FCRA requires any entity that furnishes, that's why we call them a furnisher, information to credit reporting agency conduct a reasonable investigation after receiving notice of a dispute. And this is under section 1681 S2B. There is something under 1681 S2A that says basically thou shalt not furnish inaccurate or incomplete information. Unfortunately, you can't sue for that. So this statute, the 1681 S2B, authorizes private right of action against furnishers who fail to comply with this provision. So a plaintiff can be successful if they can show the information was inaccurate and that a reasonable investigation would have uncovered the fact that it was inaccurate or incomplete. And then a plaintiff's claim will not survive a motion to dismiss without some supportable allegation that the reported information is inaccurate or incomplete. Now, a lot of times opinions just sort of shortcut this and say inaccurate. What they really mean is inaccurate or incomplete. The very statute itself, the Fair Credit Reporting Act, usually mentions incomplete first and then inaccurate. But most of the time people are just traveling under this theory of inaccurate. But this is a good reminder to us that it's inaccurate or incomplete. So 11th Circuit applies maximum possible accuracy standard when evaluating the accuracy of a credit report. That's objective. I will say this, that's really in the context of a credit bureau and what we call section 1681 E parentheses B, maximum possible accuracy. It's really not the standard when we're talking about a furnisher, but we're going to see kind of why the court mentions this. It may not be, 100% accurate, but I think it's, we'll see that the court here is kind of giving the benefit of the doubt to the consumer and still rules against the consumer. Now, whether that's right or wrong is a different matter, but I just want you to know it's maximum possible accuracy. That really doesn't have application to the furnisher. All right, so the 11th Circuit, which is the appellate court over Florida, Georgia, Alabama, as far as federal courts go. So it can be factually true and unlikely to lead to a misunderstanding. So let's back this up here. All right, maximum possible accuracy. It requires the reported information to be both factually true and unlikely to lead to a misunderstanding. So you can have something that's factually true, but yet it would be misleading, and you can sue for that. Or you could sue because it's just factually untrue. In other words, inaccurate or incomplete. So when a report is so misleading that it is objectively likely to cause the intended user to take adverse action against the subject, it's not maximally accurate. Again, this is really talking about for a credit bureau, not a furnisher. Now, here's kind of the disclaimer to that, okay? This idea of, so misleading. They say the fact that a user could possibly squint at a report and imagine a reason would not render the report objectively misleading. In determining whether a credit report is likely to mislead, the report must be reviewed, considered in its entirety. Okay, so what does the plaintiff say? You continue to report this account as charged off after being notified of his dispute regarding the current payment status. So let me just stop there. What we're talking about here is there's something called the status field, and it may say charge off. And so the plaintiff is saying, well, hey, when I paid it off, you should change that status field to show something like was a charge off, now paid off, something like that. Let me tell you what we're not talking about. We're not talking about I have been charged off for 2 years, and in January of 23, I paid off my debt. And then in February, in the payment grid, they report it as a charge-off. And in March, they report it as charge-off. And we're not talking about that. That is clearly inaccurate. We're talking about the payment status or account status field that says charge-off. And the question is that so misleading to be, to make this inaccurate so that when you do a dispute through the credit bureau, who then notifies, for example, Bank of America, the Bank of America should have fixed this. So here's what the plaintiff says. I suffered damage, loss of credit, emotional pain. And defendant says, no, you're not identifying what's inaccurate or misleading, and thus you cannot establish that required element. So the required element is you have to have something wrong with the reporting. The plaintiff says, well, look, the charge-off status misleads viewers of my credit report to believe I still have an ongoing liability when it had been satisfied after being charged off. Now remember, we did a video that talks about that until the account's paid off, there's nothing wrong with every month showing in the payment grid or payment history that it's a charge-off. Okay, and we talked a little bit about algorithms. Well, here we go. Plaintiff argues that algorithms that calculate credit scores do not consider all the fields. Instead, they view account status as the current status. In other words, let's say I paid off my debt, my charged off account in January of 23, and here we are, I'm recording this in April of 23. And if it says charge off in the account status right here, the plaintiff is saying that is viewed as saying currently in April of 23, I have a charge off. And so the plaintiff is saying, hey, that's not correct because I paid it off earlier. Because algorithms are automated, they don't make value assessments of certain data points, and so a negative assumption is made regarding the account that includes the term charge-off, even if it was eventually satisfied before the account's closure. And that's factored into the credit score. Here's what the judge says. Courts in this circuit consistently find that how third-party companies choose to utilize algorithms to decipher the accurate information has no bearing on the accuracy of the report. So what they're saying is, okay, so think about it this way. You have kind of the raw material of your credit report, and it's got facts and information in there. Now, what does that mean in terms of credit scoring? Okay, what if I had a $10,000 credit card debt and I paid it down to $1,000 over 4 months? Does that improve my credit score or lower my credit score? Well, naturally, we would think that would improve. But I suppose there could be some algorithm that looks at it that says, that's actually a bad thing. And so what the court's saying here is that we don't really care what credit scoring does in terms of, is this account information accurate and complete? We don't care what the credit scoring does. Now, credit score can sometimes come up in terms of damages, but right now we're just asking ourselves, is the fact that the account status, let's go back to here, the the account status, which is what Equifax calls it, that shows charge-off. Is that accurate or inaccurate? We don't care about damages. Is it accurate or inaccurate? And so they say how third parties choose to utilize algorithms has no bearing on the accuracy. So here's a case rejecting an identical algorithm argument on same grounds. Congress is a branch that can amend the FCRA in response to technological advances, not this court. In other words, saying get Congress to change the law if you're concerned how this is working out. Now remember, I mentioned this in a previous video. The credit bureaus, the furnishers, they love this argument that, hey, the fact that a credit score, algorithm lowers your score because of something, that means nothing. But now when it's the opposite and something that's inaccurate actually increases your score, they go, hey, judge, we can't be sued for this. This is wrong. We're actually helping him. We're doing him a favor. Well, it's the same argument, okay? We don't care about credit scores to determine whether or not something is accurate or inaccurate. All right, so here plaintiff does not dispute his account was past due before it's closed, urges court to analyze his credit report with focus on the status field to the exclusion of all other fields, and binding 11th Circuit precedent just means there's a previous case that this district court judge, who's a trial level judge, is obligated to follow. All right, so here's that Erickson case. And again, it was a credit bureau, okay, not a normal credit bureau, but a background screening credit bureau. It says the fact that some user somewhere could possibly squint at a report and imagine a reason does not render it objectively misleading. So the plaintiff identifies only the charged-off information as misleading or inaccurate. And the charge-off classification is not objectively false or misleading when the report's viewed in its entirety. So what they're saying is, if you look at I don't think the judge actually says this, but we'll look, keep going. But normally what judges say is, well, look, there's a zero balance. There's no amount that's due. So they can't possibly think that you actually owe this debt. Okay. Now the response is, well, you sort of have contradictory things here. So why are we giving the credit bureaus the benefits of the doubt when they have contradictory information? The status says I'm right now at charge-off even though I paid this off 4 months or 6 months or a year ago. And so we just have a number of cases, primarily from Florida, that say, no, you're going to lose on this argument. So because viewing the credit report in its entirety objectively shows the account at one point was past due, such that it had to be charged off. However, when it was closed, it had zero balance, so it's no longer showed as past due. Of course, that kind of raises a question, why is it still showing a charge-off? This is plain subjective understanding. And remember, they're pointing out it has to be objective. So subjective understanding does not satisfy the objective test established in Erickson. Again, Erickson's that background screening. It's sort of a crazy case where I want to say it was like a little league coaching position. They run a background check on this guy, and the credit report comes back and says, he may be like a convicted like child sex offender. And he wasn't. It was, I think, like his dad or something. And so the court said, and if there's interest in this, I'll go through that case. It's kind of a lot of details. But basically, the court said, we feel bad for you, but we don't think this was objectively wrong or objectively misleading. So here's the quote. Whether it's accurate under the act, we look at objectively reasonable interpretations. On the other hand, the fact some user possibly squint. So what is that, like third time we've read that? So you see that's really important here to the court. Can possibly squint at a report, imagine a reason, does not render it. They say it was not objectively false or misleading, so you lose. So case dismissed with prejudice. So what you have to do when you look at this is some of this we have to decide what our own opinion is, and some of it we have to recognize as a factual matter. If you're bringing cases in Florida, for example, particularly in this part of Florida, these decisions are out there. So that's a fact. Now we can close our eyes and pretend it doesn't matter, but it does matter because now there's momentum building up, whether it's right or wrong. There's momentum building up that this claim is not any good. Now, it could be that somebody appeals this to the 11th Circuit, and the 11th Circuit says, no, you have a valid claim here. So the objective part of this, to kind of borrow their language, is there are decisions out there ruling against the plaintiff, the consumer. Now, what we have to do is say, all right, do we agree with this? Do we think these judges are getting this right, or do we think they're getting it wrong? Okay. Now, there's a kind of a similar decision from the Third Circuit, which came out of Philadelphia, and it has to do with the status and primarily with TransUnion. May even be exclusively with TransUnion. So again, we can look at that and say, do we agree? Do we disagree? Is there a way, taking this opinion, knowing what the court's saying, is there a way to work around this? Okay. Well, maybe part of it is that if we believe this is affecting us, can we get some information from a loan officer, from a mortgage broker to say, hey, this is jamming you up. Okay. Now, if we get that, maybe we put that in the lawsuit. Maybe we attach as an exhibit. Here's an email or a letter. Because it says a charge-off status, we cannot make you this loan. Well, that might make a court rethink the idea of, does this affect you? Because if the loan officer, the mortgage broker said, we view this as, even though it has a zero balance, that you still owe money, because otherwise it would not have a charge-off in the status field. Well, that might be enough to get the court to change their mind. But without that, or some other way of working around this, sort of pulling this thing apart and saying, okay, how can we do it differently? Then we're going to get likely the same result until there's an appellate court, like the 11th Circuit Court of Appeals, that says, hey, this is wrong, the way that these judges are interpreting this. So this is something that's useful for you to spend some time thinking about. Again, two ways. One, acknowledge the fact that there are these bad opinions out there for a consumer if you're making this argument. And then the more creative side is to say, okay, well, is there something that the plaintiff has missed? Is there something that the judge is looking for that we've not given him that maybe we can give him to get a different result? And that's part of being a lawyer, and part of sort of the creativity of this is saying, okay, is this truly an insurmountable obstacle? Can we go around it? Can we go over it, under it, like that? What's that story? The going on a bear hunt or whatever. Can we go through it, around it, above it, below it? Or are we just blocked here? And, is there something else we can find on the credit report? I think this was, right here. Identifies only the charge-off information is misleading or inaccurate. Well, is there something else we can find? Okay. What if there are 5 things that are wrong with this account, and we only mention one of them to the credit bureau, and we only sue on one of them, and then we lose that? Well, we're done. But what if we mention all 5 to the credit bureau, and then we sue on all 5? Well, we might lose this one, but maybe the other 4, the judge says, hey, those are perfectly valid theories. And so this is why it's worth spending some time really dissecting these reports, understanding the errors, making sure we present all the errors to the credit bureaus, that we make it very, very clear, very understandable what we're doing. This is not time to be cute or to be vague or ambiguous. Tell them what's wrong. Say, hey, look, on this month, this information's wrong. Hey, this field contradicts this other field over here. Be very, very specific. I love to show them what's wrong. Okay, so a credit report, whether you draw it by hand or use like a PDF program, but you circle something here, circle something there, you draw an arrow, like, hey, look at these things, they contradict each other. You want to get as much of this out there so that it's very hard for the other side to argue that the whole case should be thrown out, and it's very hard for a judge to accept that. All right, guys, thanks for watching this, and let me know your opinions in the comments below, and we'll keep doing these case videos. All right, thanks a lot, guys. Bye-bye.